morning, everybody. So good to see everybody today. We have Bob Post here that's going to be our first speaker, and we're so excited. He goes to our church, and he's been awesome to help offer this today for us. And then later we're going to be joined by Karen Best, and she, unfortunately, her husband is ill, and she did not want to spread that to us, so she's going to be joining us through Zoom. So the papers that you have in front of you are going to be what Bob is going to be talking about. So what we'll do is have him speak, and then when we have questions, I'll bring this microphone around to everybody so that we can, because we're recording, and Karen will be able to hear us, and then anybody else who wasn't able to make it today will also be able to hear us. Okay, would that be all right? All right, well, let's start with a prayer. Dear Heavenly Father, we thank you for your bounty that you give us every day, for all the blessings, including this one, Lord, and we are just so grateful for the information to help do the things that we all have to do in this life to make things easier on ourselves and on our family, and just to get all the information that sometimes seems very confusing, and hopefully by the time we're done with this, we'll have a lot less confusion and a plan to go forward. Thank you for this time, and bless our time together. In your son's name we pray. Amen. Amen.
Good morning. Good morning. Everybody hear me?
Yes.
Can we?
Margot mentioned I am a member here.
Okay, hold on one second. We can almost hear you.
I'm sorry, I forgot to turn it on. As Marco mentioned, I'm a member here, and I'm a local attorney in San Angelo, for any of those that don't know me. And my practice at this stage of my career is mostly in real estate, estate planning, and probate. So, we're going to start talking about wills. And I'd like to open up by reading an example of how you probably should not make a will. This is a rather famous will that was written in the 1930s during the Great Depression. It's called the Oberweis will. And so I'm going to read it. I am writing of my will, myself, that damn lawyer he should have too much money. He has too many answers about the family. First thing, I don't want my brother Oscar to get a GD thing. I got it. He is a Moser. He done me out of $40 14 years since. I wanted that my kid sister Hilda get the north 60 acres of that where I am homing it now. I bet she don't get that good enough husband of hers to break 20 acres next plowing. She can't have it if she lets Oscar live on it. I should have it back if she does. Tell Mama that $600 she's been looking for 10 years is buried from the back house behind about 10 feet down. She better let little Frederick do the digging and count it when he comes up. Pastor Luknitz can have $300 if he kisses the book. He won't preach no more dumbhead talk about politics. He should a roof put on the meeting house, and the elders should the bills look at. Mama should the rest get, but I want it so my brother Adolf should tell her what not she should do. So no more slick Irishers sell her vacuum cleaners. They noise like hell, and the broom don't cost so much. I want it that my brother Adolf be my executor, and I want it that the judge please make Adolf plenty bond for that, and watch him like hell. Adolf is a good businessman, but only a doom call would trust him with a busted finish. I want damn sure that Schlemel Oscar get nothing, don't nothing get. Tell Adolf he can have $100 if he proves judge Oscar don't nothing get. That damn sure fix Oscar. Signed, Herman Oberweis. Okay. That's not how you want to do it. So, you've got an example of a will in the handouts. And And so I want to talk a little bit about what the requirements of a will are. A will needs to be dispositive. In other words, it needs to say what's going to happen to the property to be effective, obviously. The person who signs a will needs to be of sound mind and over the age of 18, unless they've been emancipated. You know, once in a while somebody gets emancipated by a court if they're not yet 18. A will in Texas and in really pretty much all states has to be witnessed by at least 2 other people. And unless it's 100% in your own handwriting. You can write out a will cursive or print a will, and it doesn't have to be witnessed if it's completely in your handwriting. I don't particularly condone that or recommend it because then somebody has to prove that it is your handwriting. But holographic will, which is what that is written out, is valid in Texas. When a will is being probated, it has to be what we call proved up. If it's witnessed, but not self-proved, and I'll explain what that is in a minute. If it's witnessed but not self-proved, normally what you do is you bring one of the witnesses in and testify that yes, they were there and they saw it being signed and everything is correct, and then the judge will enter that will into probate. Most wills nowadays that have been prepared by an attorney are going to be what we call self-proved. If you look at the last page of the handout will, it has basically what's an affidavit. The page before that will have signatures and witnesses that make the will a valid will. And then that last page is an affidavit that self-proves it. It's going to be notarized. It's going to be signed again by the testator and the 2 witnesses, and then notarized. And with that affidavit, a judge will admit that will probate without bringing a witness in. And so it's just so much more convenient when you're probating a will to have it self-proved. It's not required to make it legal. It just makes it easier to prove it out. Okay, if you die without a will, what happens? That's called intestate, and basically the state of Texas determines how your property is going to pass. And let's talk about that for just a minute. You have to remember in Texas we're a community property state, and so you have to figure out what's community property and what's separate property. In general, separate property is property somebody has before they get married. It's also property they inherit while they're married, and it's also property given to them if it's given just to them while they're married. Anything that's accumulated while you're married through earnings is community property, unless there's been some sort of a pre or anti-nuptial agreement that's been agreed to that changes that. And so, if somebody dies without a will, community property is already owned by the surviving spouse, half, an undivided half interest. The other half would go to the surviving spouse if every child of the deceased spouse is also a child of the surviving spouse. However, if the deceased spouse has a child by a prior marriage that's not a child of the surviving spouse, all that community property is going to go to all the deceased spouse children, whether some of them are the surviving spouse children or not. It's going to go to all those children equally, and the surviving spouse will get none of that community property that belonged to the deceased spouse. Most of the time, that's not what people want, and that's a good reason to have a will. Separate property is kind of confusing. If a person dies without a will, and they have separate property and they're married, 1/3 of the personal property, which is everything that's not real property, not real estate, goes to the surviving spouse. 2/3 goes to the children or the descendants of the deceased spouse. And as to real estate, the surviving spouse gets a 1/3 life estate. And then the descendants get the other 2/3, and then the remainder interest into that 1/3 life estate. And there is no exact way to put a value on a 1/3 life estate. I mean, those have to be settled by agreement. The IRS has tables they use for tax purposes, but that doesn't mean that's exactly the way you value it. And so, and that's something that came through Texas, from Mexico, and all the way back to Spain in the way they did this 1/3 life estate. But it's still the law here in this state. When somebody does die without a will, you have to, and they leave property, then we have to deal with it. And actually, to me, this is sort of backwards in the way you would think it should be. Real estate is the easiest to deal with when someone dies without a will, because by tradition, we accept affidavits of heirship for the ownership of real estate. You know, at the title company I work at, we pass a title on lots of properties where somebody has died in the past without any probate through an affidavit of heirship. But a bank, an investment firm, if you have stock, they will not pass by an affidavit of heirship. You would have to go and do what we call an administration of the estate without the will. Now, you have to do an administration of an estate without a will. If all of the heirs agree, it can still be an independent administration, where a judge signs off on it, and you have an independent administrator appointed, and then it becomes much like administration with a will, where you don't have to give the judge's approval on every little thing you do. But it's still going to go under the laws of descent distribution. If you have any of the heirs that don't agree, then you're going to have a dependent administration. And that means every time you want to pay an expense or do this or sell a piece of property, you got to go make an application to the court. Then you got to go get the court to approve it. And it just is a real pain. It's not something anybody ought to want to go through. The other thing that you have to do if someone dies without a will, even to do an administration, is you have to have a determination of the heirship. In other words, the court's going to have to rule on, okay, this is who the heirs are. You have to file an application for that. The court's going to appoint another attorney to be the ad litem that represents all these heirs, to make sure somebody's not telling the court something that's not really true, and that there are some other heirs out there floating around. And so it gets more expensive, and you have to do publication and that sort of thing. But it's not the end of the world if somebody dies without a will. There are methods to get it handled. It's just more burdensome. Now, when you do have a will, and if it's self-proved, it's pretty simple to get the probate started, and you get the executor appointed. It usually has to be on file for like 10 days, and then the Monday after that. So usually within 2 to 3 weeks, you can get a hearing, have the executor appointed, and then with a will that sets up for the executor to be independent and with no bond, once the judge signs that order, the executor's off and running. They're a fiduciary, they're supposed to do everything right, and they're liable if they don't, but they've got the power, and they're not having to go back to the court to seek approval for things. And that's what most people want to happen. The other thing to remember too is what is a probate asset and what's a non-probate asset. For a probate asset, everything that you own that you haven't set up a payable on death or beneficiary. For example, if you have an IRA or you have an investment account somewhere and you set up beneficiaries, That's gonna go by contract. Also, life insurance policy, same way where you have beneficiaries. That's gonna go back to those beneficiaries outside of the probate. The will's not gonna have nothing to do with that, because that's already got its own beneficiary. And so that's something to remember too. And when you're doing a will, you've gotta take into consideration what you may have done with beneficiaries and all this other, so that you're making sure the big picture is what you want, and the way you want everything to go. Now, this will that you have in front of you, I like this format. This is kind of an outline format, and basically it tells you on the first page where property's going. You don't have to kind of read through all the legalese to get to who gets what. It's also got a contingent trust provision in there, and that's set up so that if somebody that's a minor or below whatever age you think is appropriate, it might be 25 or 30 or whatever, if they're below that age, it's going to go into trust for them instead of outright. And because it's if you have a minor and they're getting something outright, that becomes a problem with having to get a guardian for them or dealing with that. And you got to remember, you may have children that are all adults, but if one of them predeceases you, in your method of disposing of your property has that part go to the children of the deceased child, all of a sudden you could have minors on your hand that you didn't think about originally. And so a contingent trust clause, it's not setting up a trust, it's making a provision so a trust could be set up at the time of your death if there was a necessity for it. And then, of course, if you get to like page 4 in the, let me see, or page 3, that's where you name who your executors are going to be, and you can do it with successor executors behind the first one, if for some reason they can't serve, and also trustees. If you look on, I'm jumping around a little bit here, let's see. Okay, if you look at page 4 at the top, this is sort of magic language under executive powers that make an administration independent of Texas. You say that no action shall be had in any court or probate jurisdiction in relation to settlement as a state other than probating recording of this will and the return of the inventory and required appraisement in relation to claims of my estate. That makes it an independent administration, where you don't have to go back to the court for permission. However, it does not give the executor the power to sell. And so, and we bump into this in real estate all the time. You can have an independent administration in the will, but if it doesn't grant the power to sell, and you want the executor to be able to sell property, then you gotta go back to the court to get permission. But if you make sure the will has somewhere in there additional powers, in this case, the next sentence says, in addition to having all the powers of independent executors under the laws of Texas, the executor shall have all the powers given to a trustee in this section. And down here, we're going to give the power of sale. And so that gets incorporated to the executor too. So that's one of the things, if you have a will out there, it'll probably be set up for an independent administration. But you want to make sure it's got broader powers, either of all the powers that a trustee can have under the trust code, or specifically say the power to sell, if you want them to be able to sell property. Now, a will can be revoked by several ways. You can sign a written document saying I revoke that will. Usually when you make a new will, it'll say in it at the top, I revoke any previous wills. But you can also revoke a will by tearing it up. if you tear it up, there's a presumption that you meant to revoke it. Now, that brings up a question. Once in a while, somebody will die, and the family will come in, and they'll say, you know, we've looked and looked, and we can't find the original will, but we have this copy. And it shows there, everybody signed it and everything. That can actually be probated under the probate code, or the state's code now. But you have to overcome the presumption that it can get revoked. And so you gotta get some testimony in there. If there's no reason to think they revoked it, usually we can get a copy that's now it has to be a copy that has all the signatures on it. It can't be like a draft copy. But usually we can get that probated. But when you do probate a copy of a will, you're gonna have to get notice to everybody named in the will. But you're also gonna have to get notice to anybody that would have been an heir under descent and distribution, to let them know that you're trying to probate this copy of the will, and they have the right to come in and say, well, no, we think it got revoked. So you've got to give all that notice to people in case anybody wants to come in and contest it. But it is possible to probate a copy of a will. Another requirement for probating a will in the normal manner is that you have to do it within 4 years of when the person died. Most of the time, that's not an issue, but when we're trying to clear title on property, you know, we come across situations where they had a will and nobody thought they needed to do anything with it, and they didn't for 4 years or more, and now they want to sell property and they don't really want it to go by the same distribution, they want it to go the way the terms of the will said. Well, here's what the law says about that. A will can be probated as a muniment of title. And what that term means is you're probating it to work like a deed. You're probating it to pass title to property, but you're not going to have any kind of administration. You're not going to have an executor. You're not worried about paying bills. All that's been taken care of. You're just trying to clear the title of this property. But to do that, the applicant has to be able to show that they were not at fault for not probating it during the first 4 years. So let me give you some examples. If the spouse dies and the surviving spouse knows of the will and doesn't probate it and it's more than 4 years, probably not going to be able to get it probated as an in the title to clear the title of that property. On the other hand, if that spouse then dies and then a child discovers, here's the will, I don't know why they didn't probate it. That child's not at fault. It was the other spouse that died later that was at fault, and so they can probably get it probated if they need the title to clear the title. And also for muniment title, you've got to show that there are no unpaid debts, that all the other bills and stuff got taken care of. Okay, so what I would like to do now is let's move over to the statutory retirement plan and talk about that. A lot of people refer to this as a legal power of attorney. It's, when it says statutory, what that means is, if you look at the powers being granted at the bottom of the first page and the top of the second page, it just gives you like a description, a title description. The statute that's behind this form goes into great detail of what real property transactions means, and what tangible personal property transactions mean, and what stock and bond transactions mean. And all that's incorporated by reference, so that we now have a 5-page document instead of a 20-page document that has all the details about all that. That's what statutory means. Durable means that if you become incapacitated, the power of attorney continues to be in effect. If you don't have special language in the power of attorney that makes it durable, it's presumed that the principal who signs that to grant power to an agent, if they become incapacitated, they would be revoked. But if you put language in there, then it continues if you're incapacitated. Okay, so it lists all these powers of things that could be done on the bottom of the first page and the top of the second page. In the real world, most clients end up initialing the one labeled O on the second page, which is all of the. If you initial that one, you don't have to initial every one of these other ones. It just says all of them. And most people, if they're doing this just as a planning for the future, are going to want to grant their agent all those powers, because you don't know what they're going to need to do. There are situations where you might need somebody just to do one thing, and you might make it just one power. But usually when we're doing these powers, you're going to initial O. This form, then, if you look at the next two blanks, it's got two options. You can say that your agent's entitled to reimbursement of reasonable expenses and to compensation for having to do things, or you can say that my agent is entitled to reimbursement of reasonable expenses, but not for additional compensation. My experience is if you're dealing with family members, usually that second one is chosen. You're usually not paying them to do it, but you want to make sure their expenses are covered. But there may be situations where it's extensive and they're having to do a lot, and you want to let them be compensated. And that choice is right there. The next set of things to choose on deals with co-agents. Now, co-agents are only if you name two people to serve at the same time. If you name a person and then successive people, you don't have any co-agents, and you would just leave that blank. But if you do choose to have two or three or more co-agents, then you need to be definitive and say either one of them can act independently, they don't have to go get the other ones to sign, or no, they can only act if all of them join in and sign, or only if a majority of them. If you picked three, obviously if you picked two, you wouldn't say a majority, but if you picked three, you could say two of the three could do it. So it gives you your option there to pick whichever one of those you want to use. And there at the bottom of the first page, and we used to see this used a lot more when the estate tax limits were way lower, and a lot more estates were lumping into them. It allows gifts to be made by the agent, and that was done most of the time for estate planning. You might have had a parent that was giving each child, $10,000 a year, trying to keep their estate from getting too big. With the upper limits now, it's usually not, with most estates, it's not necessary for estate planning, and I see it chosen a lot less common. But if you had a parent that is making systematic gifts once a year, they might want to initial that to allow those gifts to continue by the agent. And this power of attorney doesn't have to be witnessed, but it has to be notarized. And then it can many times avoid a guardianship later if a parent becomes incapacitated, they can't pay their bills and do things. If you have one of these in place, it can do wonders for helping with that.
Do we want to wait to the end to ask questions, or after each?
We could go ahead and take questions now. If you had questions on the power of attorney and on the will, and then the other documents are going to be a lot quicker going through. And the other thing I need to mention is, once in a while I have somebody come in and such and such has died, but they have the power of attorney, and I have to explain them. Once they pass away, that power of attorney is void. You can't use it like a will or anything else. So, does anybody have any questions right now?
Explain the
gonna pass around a microphone.
Can you explain that again, please, about the power of attorney after death?
It's void. It's just void. I mean, once the person that signed it dies, you can throw it away because there's no authority to do anything in it.
A couple of questions.
Okay.
Let's go back to the will. Number one, if you leave all your possessions to your spouse, that spouse can disclaim part of that, can't they, which would transfer on down to the next generation or the children?
Yes, and also, I mean, if you have a really large estate, you know, there's other things you can do. There's a marital deduction. Basically, even a huge estate, if you leave enough to the surviving spouse, there's no tax when the first spouse dies through the marital deduction. But you can leave property not to the spouse up to the amount an estate can have. And that's what we typically call a bypass trust. And it's there, even the income can be used for the surviving spouse, but it's not their property outright. And then that goes down to the descendants later. But yes, now that's disclaiming is something that you can do after the death. It gives you more planning capability. If something is left, whether it's to a spouse or to a child, they can disclaim it. And if they disclaim it, they can't have already accepted it and used it for a while, but if they disclaim it before they get it, it goes to how it would have gone if they had predeceased. So it can also be done by a child that wants it to go down to grandchildren. And so, yeah, that's the disclaimer.
And going back to the estate tax, I know, number one, it's just taxable on the half of the estate, correct?
Correct.
Okay. Now, number two is, it seems like to me the deductible right now is really high, but there is some point in time in 2025
Yes,
that law may disappear, and then the deductible will be what?
Okay. Well, it's called a credit exemption because they grant it as a credit against the tax, but you can talk about what the size of the estate equals to. Okay, so the law was changed at the end of 2017, effective for 2018. And it expires in 2025, unless it's renewed. And odds are, if it gets renewed, it'll be tampered with and changed a little bit, we don't know. So the way the law was written, if it just expires and nothing else happens, the estate tax limit goes to $5 million, but adjusted by inflation since 2018. Most experts think that it's probably close to $6 million. And that's per person. And used to be, we had to do, if you had somebody with a $10 million estate, they would have done the bypass trust and the marital deduction and all that. They also made a change in the law, what they call portability. So even if you don't have a bypass trust, you just leave everything to the surviving spouse. If when the first spouse dies, if they go ahead and file an estate tax return with the IRS, even though there's no tax due, and a lot of people will say, well, why am I going to file it? But to get the portability, you've got to file that return, and then you get the full $6 million plus whatever it is when the second spouse dies. So that means if you filed the return when the first spouse died, it would take an estate over $12 million to ever be looking at any kind of estate tax, even when the other law expires.
I think I have a pretty simple question. There was a law, I think, that was signed the latter part of 2017, maybe 16, about transfer on death deed for homes, and then also for cars, where if a parent dies, the children remaining do not have to go through an estate. And not many people know about that. But it's called transfer on death deed, and you have to have the papers signed, filled out and signed and filed with the county.
Right.
Okay, could you address that again? And that's not what you were talking about a while ago.
No, I didn't talk about the deed, but I can. Even before they passed that law, we had something called the Lady Bird deed that sort of did the same thing. And then they just, they passed a statute where you can do a transfer on death deed. A lot of attorneys still prefer to use what they call the Lady Bird deed. The Lady Bird deed is, it retains a life estate for the person that signs it. And it can be for two spouses, and then it goes to whoever you name, usually children or whatever, upon the death of either the one spouse or both spouses. That's a traditional life estate deed. What the Lady Bird deed did was it did that, except you reserve the right to sell the property. You reserve the right, if you got mad at one of them, to take them off and put somebody else down as the remainder. But when you did die, it went automatically, and it's not part of your probate estate. It's like a beneficiary designation. The Lady Bird deed was actually invented by an attorney in Florida, is my understanding, and it was done, well, let me explain. There are a lot of people in smaller estates that go to a nursing home and don't have, and qualify for Medicaid. Now, Medicaid means you can't have very much monthly income, and you can have a very large estate other than your homestead. What happened was, if you're getting Medicaid to pay for a nursing home, when that person died, they were filing these, what they call MERP claims on their home. And so the descendants of the children, if they went to sell that house, they had to pay off all that Medicaid benefit. The Lady Bird deed got around that, because a MERP claim is a claim against the estate, the probate estate. And so anything that a beneficiary puts through, they can't get. But what really made the Lady Bird deed work, if you had just done a life estate deed, that's considered a gift. And there's a 5-year look-back rule. And so if you went into a nursing home in the next 5 years, you didn't qualify because of the look-back rule on that gift. The Lady Bird deed, well, it's an Indian gift. I'm giving this to my kids when I die, unless I change my mind. Because I can take them off, I can sell it, I can give it to somebody else. Yet, when I did die, and it did go to them, the MERP claim they had nothing to grab because they'd already gone. And so it actually still works. So that's why the Lady Bird deed came around. But now you can do deeds on homes to kids, with, whether it's a Lady Bird or the good thing about the Lady Bird is it always gives the person, it's like a will, you can always change your mind. But yes, it's the same thing as doing a bank account, beneficiary designation, or whatever. You can do that with real property, with the deed. And on car titles, you can actually, if you buy a vehicle, you can, on the title, you can provide for a survivor on it. A lot of spouses do that. I don't see it done near as much for kids, but that can be done.
But it's called transfer on death.
Yes. But a Lady Bird deed does everything that a transfer on death deed does too. It's just another slightly different form.
I have a question. On the power of attorney back here, Mayor.
There we go.
On the power of attorney, you said that on the death, the agent of the power of attorney has no more authority.
That's correct.
Then who does?
Well, if there's a will and we probate the will, the executor,
The executor of the will, okay.
right?
My husband passed away in 2020, and I never probated his will because I was the surviving spouse. Do I need to get
What?
that done before
What month did he pass away?
October?
Okay, so, if 4 years have not passed yet.
Right.
If you have a reason to probate, you still can. So now that becomes, are there any,
What would be the reason?
it would be if there are any assets in his name that are frozen that you can't get to.
Okay, the only thing that's in his name anymore is our house, but it's in both of our names.
Right.
Would I be able to sell it without probating his will?
Here's what, in the will, it left it to you, is that correct?
Yes.
Did he have children that were not your
No.
children?
No.
Okay, then you're the heir to it also. So what you would have to do if you go to say, you would not have to probate the will. You would have to sign an affidavit of heirship.
Right.
And what we would normally do, since you state in the affidavit of heirship whether the deceased died testate, which means with a will, or intestate. What we would do is we would say he died testate, we would put a copy of that will attached as an exhibit to the affidavit of heirship. And we would be saying in the affidavit of heirship, you're the only heir. And also in the will, which wouldn't probate, you were the only heir. And so the title company sees that and says, okay, we're not worried. This is definitely the person who owns the house. And then you would have no problem selling it. But you would have to do that. That would just be an extra document that had to be signed. And you want to keep that will where you could attach it to as an exhibit to that affidavit of heirship. And you could do it now if you wanted to, but you don't have to. But that's how it's going to get clear.
Well, and I don't see me selling it, so it would go to my son. But I have a deceased son also that's in our first will that we both did at the same time. Do I need to go back and do a new will and just name my surviving son?
Okay, did the deceased son have heirs that you would want to take care of?
No.
Okay, if the wording of that will is that it went to the two of them, and I don't know, did it say, and to their heirs if one of them predeceased you? I mean, yeah. Obviously, but he had no heirs. You're saying his next of kin would be his brother, you and then his brother? Then that it's gonna go to the surviving one even if you don't change it.
I have a different issue, and I want to ask you a question about this. Bob, one of the questions that I dealt with as a minister for years and years and years were families that were at war after their parents died, or who got this and who got that. In this will, and I've used this particular format to do with wills, and in this section called gifts, is this the place where you need to be very specific about who should get grandma's ring, who should get Pa's this or that? Is that the section where that needs to be listed in your will?
There's several ways to do that. One is the will itself can say that. And then I have a lot of people that want to put a general clause in there. Yeah, it says under C1, I may express my desires as division of such of these items in a letter to my executor.
Okay.
What you're doing is you're empowering an executor to distribute certain things to certain people. You can do that.
Well, the reason I say that is as a minister for 4 decades, I saw many a family torn up over that. And I would urge people to have their children be mad at them rather than at their siblings the rest of their life, because they named it and they put in there who got what and did it because they don't want their kids to be fighting over it the rest of their days in mad. And I really encourage you to do it.
Okay, Bob, so you're talking about like if I remarry, okay, so when Ernie died, everything was left to me, and I did not probate, and it's been 15 years now.
But everything's in your name now?
Everything's in my name.
Okay.
Some of us are still joint, so I'm in cars, but I have to go get the airship thing. One of the cars is in my name.
What you need to do is check with the institutions you're dealing with, and see if you were a beneficiary survivor, and they just never bothered to rename it, if that's the case. I mean, are they reporting income to your social security number, not your first husband, or your husband's?
No, it's mine.
Yeah, I suspect it's yours, and they just haven't changed the name of the account, but you can check with them and verify that you were a beneficiary to that, and that it's your sole account.
Who said, if I remarry,
So my will would be leaving everything to Travis's will evenly.
Right.
So, except for now we're having babies, and I gotta rethink that one that you said. But, which is a wonderful thing, but, okay, so if I remarry, that would still everything, cause I'm bringing it into the marriage, that would go to Travis's
Okay.
will.
Your separate property is your separate property until the time you marry. And then it's still your separate property unless it gets commingled. We haven't talked about that. If you keep, well, a lot can be done with a prenuptial agreement that says everything that's, it's gonna stay separate. The problem is income off separate property technically becomes community property unless it's agreed otherwise. So that's one thing that can sneak up on somebody. The income can become, but also, if you take money and mix it in with other money, then it can be commingled where you can't figure it out again, and then it can become community. But if people are careful, that doesn't ever happen.
I think we'll take a couple more questions, but then get to the rest of what Bob has to say. And then we also have Karen that's gonna be speaking too. So if you have a very specific question about yours that's, got a lot of detail, I think Bob might hang around, I'm hoping a little bit afterwards to answer those questions. But if you have a general one that you think will benefit the group, then let me know.
Oh, here's something I run across is my role as a POA that you might want just to address. One is found that not all companies, banks, etc. recognize a POA. They can either, they'll tell you, we don't recognize it. The other is that the Fed don't really recognize POAs, but there's a form you fill out that gives you the authority, gives them the authority to use, to be a representative of someone to them, but you're not a POA. Basically,
That's correct. I mean, if you're dealing with the IRS, they've got their own forms that they want you to use. But, now, a third party, like a brokerage company or somebody like that tells you they're not going, or a bank tells you they're not going to accept the power of attorney. If it's a good power of attorney and it's really not defective, a letter saying, well, we're getting ready to sue you if you don't accept it, will usually change their mind. because the law, I mean, it's the law. They can't just say we don't want that. Now, it has to not be defective. I mean, sometimes they'll have a reason they don't want to take it. But
would you suggest, we have 2 children, would you suggest that we give each one of our children a copy of our will so that they would have it, and then we have the original will?
I mean, that's a personal question depending upon relationships and things, but,
it's all good.
yeah. If everything's good, I think that's a wonderful idea. Yeah.
Are we gonna talk about trust?
Probably could, I'll be glad to talk to it afterwards, probably, because for time reasons.
Okay, thank you. And thank you for
Okay.
staying.
Was there one other question in the back? Yeah.
This is a quick question. If you have an adult child who has no heirs or spouse, and they pass without a will, where do their assets go?
Okay. So they're an adult, and so if they have no descendants, they go half mom, half dad. If they're predeceased, it goes to their descendants, so it means siblings. It's gonna go to siblings. If there's no sibling and no mom, dad, it goes to grandparents, and then it works its way down to cousins. But probably in the question you're talking about, it'd probably be sibling, yeah.
You talked about listing different folks possibly as power attorneys. Do you just list those all where it says Mary Doe here?
No, at the you list the one person on the front, and then on the very back, you get in front of you. Not the important information, but it'd be on the third page, paragraph above the signature. If any agent named by me dies, continue past day resigns, blah, blah, blah. I name the following, each to act alone and successively in the order named as successor to that agent.
And so you
can name 2 or 3 people there, but it would be in order, or or it can be customized. If this person doesn't do it, I name these 2 to be co or whatever.
Okay, great, thank you.
Okay, so let's move on to the medical power of attorney. And the medical power of attorney is just what it sounds like. You're granting to an agent the right to make medical decisions in case you're incompetent or under anesthesia or whatever. And the main thing about this is it really is not set up to have co-agents. It's set up to have, alternates. So you name a person, and then you can have a first alternate, a second alternate. But they don't really want 2 or 3 people by committee, because that gets confusing for the doctors and hospitals and stuff. And but other than that, it's pretty self-explanatory. And it used to be these were all only witnessed by 2, but now you can either notarize or have a witness.
If you're the spouse, are you automatically able to do that?
It's better to have that and name the spouse. That's what we usually do, is name the spouse first and then the children.
Bob, they've got to have this. Spouse has no right.
That's what I said. I said it's usually better to do that. Now, in the real world, if you don't have one and it comes up, they will probably work with you somehow, but they are uncomfortable. They want that.
Yeah.
Right.
Now, the hospital will not grant you power if the patient hasn't given you the report.
That's right. I agree.
So do you give that to the hospital, here, example, with.
What I would do is I would hang on to the original. I would make copies.
They will make copies for you.
And then it's good to have the hospital, or any other, here we've got pretty much everything with Shannon. So they have a central record place where you can have it on file. But if you're using other offices or something, yes, but you give them copies. And if they want to see it original, they can see it, but you don't let them have it. Okay, the next form is the directive to physicians. And I have a lot of people come in and say, I want a DNR. This is not a DNR, it's a directive to physicians. And it does a couple of things. Down under the paragraph under directive, the next paragraph down, it says, if in the judgment of my physician, I am suffering with a terminal condition from which I am expected to die within 6 months. That would be common for a terminal cancer diagnosis, possibly kidney failure, even a heart failure maybe, those sorts of things. If they're saying, you probably got less than 6 months, you can request, you have 2 options. You can say, only keep me comfortable, don't keep me alive longer than necessary, or you can say, you do everything you can to keep me alive. It gives you that option. Okay, most people don't want to do everything, but somebody might. Okay, the second thing under that it says is if in the judgment of my physician I'm suffering with an irreversible condition. That gets kind of confusing, but I equate that with not like a cancer or that type of diagnosis, but maybe a sudden massive stroke or something like that happens. And it's the same, It's a different condition, but it's the same part that you fill out as to whether you want all treatments or no treatments to keep me, alive indefinitely. Now, if you go down to the middle of the second page, this is what I call, it says, if I do not have a medical power of attorney. Well, if you have a medical power of attorney, you don't even fill that out. And that part I've X'd out, I call that a poor man's medical power of attorney, in case you're doing one of these and don't have one. But most of the time we use the more explicit medical power of attorney, we just don't even fill that part out. Okay, so this is letting the world know that you don't want to be kept alive artificially if you're in a basically terminal condition. It's not euthanasia, but they can withhold a respirator, they can or take you off the respirator, withhold feeding tubes, things like that, and you die naturally. There is this other form. This is an out-of-hospital DNR. The hospital has its own DNR too. These are really in conjunction with the patient, but really it's a doctor signing this. Only a doctor approves a DNR. And that means there's not going to be powders put on you or anything. You're ill, you're probably going to die before too long, and they're telling the staff, we're not doing any of this heroic stuff to keep them going. But a doctor has to approve that. Whether it's this out-hospital, which could be in a nursing home or somewhere, or the hospital form they've got themselves. So that's the difference between a DNR and a directed decisions. And then I gave you a copy of the HIPPA release form. And that's, nowadays, if you're not the patient, you're not getting records without one of these, whether it's a spouse or anybody else. That's just the law, so because of confidentiality.
My stepfather had a pacemaker that was also a defibrillator, and in the event that they're like on a terminal track, you do not want that defibrillator to kick in because it will terminate their life, and you want to make sure that they sign that DNR ahead of time so that they can turn that off so they can pass gracefully and easily and in the way the Lord intended. Because if that defibrillator kicks in and they're in an ill state, it'll terminate and it'll be extremely painful and a horrid way to die.
Yeah.
So just to know that, because we didn't know that and a friend told us that. And so we had them come in and do whatever they had to do with the pacemaker. And it's peaceful to know that he passed gracefully.
Okay, I guess it's Karen's time.
I think so. Karen, I hope you're ready. Can we see? We might have to do a little bit of switch over here. Thank you so much, Bob. Let's have a hand for Bob.
Can you hear me okay?
Karen, so good to see you. Thank you so much for being with us.
Well, I wish to be with you in person.
I know we miss you, but you have a beautiful face and we're lucky to see you today. Thank you.
You're very kind to me. Unfortunately, if it were just a small cold or something, I would be there, but unfortunately it's the big C. I haven't seen that one around here in a while, but I didn't want to bring it in and share it with everybody. So you have me from my living room today.
Right, well, we're ready to hear you, I think. I don't believe we have any of your handouts.
I think there is a long text string conversation going on about having copied the wrong presentation to take over. My staff are trying so hard to get everything done for me from afar, but they don't want me anywhere near the office. So I'm going to do my best to screen share. If that doesn't work for whatever reason, I want to pick up where Bob left off, and he did such a beautiful job in presenting really the essentials of an estate plan in Texas. What happens, and is it time for me to just kind of go into things?
It is.
All right, so everybody, I'm so glad to be with you today. I'm sorry I can't be with you there in person, but I wanted an opportunity to talk about the documents and that Bob just talked about, and put a little bit of a spin on them based upon what I see in my office. And so I don't do title work or anything like that, but I do work with families who are in crisis. And so effectively, we as attorneys just love the idea that we paper you up and you pay us and we give you beautiful documents and you put them somewhere safe, wherever you put them. And somehow when it's time to use them, you pull them out and it's seamless, right? Everything just works. And sometimes they don't. And not because the attorney did something wrong or the person involved gave wrong information, but just because documents can only go so far. And so when, what I want to talk to you about today is, it's not really an issue of going back on anything that's been said, but adding to it, if that makes any sense. And so there's a reason when we get older, we end up in the attorney's office more often than maybe we ever did before. It is quite often the case that someone is coming into my office because there has been an event. Either a husband has dementia and has to go into nursing home. For the men who are sitting there today, when I talk about these things, please don't take it personally that I'm always giving your husbands or the men dementia and putting them in the nursing home. I am an equal opportunity person here. I will always kill off the wife first in my examples. One's going to die and one's going to be in the nursing home. But when people come in and they sit down with me, it's usually because something has happened. And so quite often a spouse will come in and they have somebody who is in the hospital and it's clear that they're not going to be able to take that loved one home. And so they're pulling out all of those wonderful documents that Bob just talked to you about. And perhaps they did these documents like the financial or the statutory power of attorney prior to 2019. And they feel like they've had those documents, they've paid good money for them, they're on legal paper, they were witnessed with a notary, they should be just fine. When we get into trying to figure out using that document, we sometimes run into problems because in 2019, right in the height of COVID and the pandemic, the legislature had passed a change to the Power of Attorney Act that is the law in Texas that governs those powers of attorney. Can everybody hear me okay? Yes. Okay, so when that changed, it specified certain superpowers, I'll call them, and you'll have those set up forth, and Bob talked about those, that are in there that you have to specifically initial. And so in the old form, it didn't have them set out. And so, for example, the special power that you see in that document before you that talks about the ability to make gifts, where the agent can make a gift to themselves. That wasn't specified in many of the old forms. Depends on the lawyer, but if you're using the statutory form put forth by the state of Texas, it wasn't a set-aside power. And so now, if it's not a set-aside power, you can't do it. And so you might think to yourself, well, that's not so bad that my agent can't make a gift to themselves. But sometimes it is bad that they can't do that. And so, for example, when I have somebody come into my office and their husband is in the hospital and he has dementia and he's fallen and he's going to go to rehabilitate in a nursing home and the like, and it's clear after they're in the nursing home for a period of time that he's not going to be able to return home, the wife pulls out that power of attorney, that financial power of attorney, and they come in and they go, how do I get Medicaid? Because as y'all probably know, some of you will, I have my first nursing home here in San Angelo that is running $10,000 a month. So we're not talking a low amount of money coming out of the checking account to fund care after Medicare stops paying. And so we'll get more into that in a moment. But the power of attorney she pulls out, under Medicaid's rules, I can often allow that spouse to move assets out of husband's name into an account in only her name so that it doesn't have to be spent. It's called spousal allowance, okay? And also, it goes by spousal impoverishment. It has very specific acronyms for Medicaid, but I'm gonna go by the nickname, okay? So it's fantastic, right? You go, oh my gosh, this is wonderful. I'm not gonna have to lose the farm. And then she pulls out the power of attorney, and it doesn't allow her to make a gift to herself of that money. It doesn't allow her to go into the bank, into an account that may be in only his name, and withdraw that and put it into her own name. It doesn't allow her to go in and create a ladybird deed, that wonderful deed that Bob was talking about that would avoid Medicaid. Well, a lot of people love the idea, but maybe haven't executed one or hadn't gotten around to it yet. And so we need the agent under that power of attorney to be able to do that. But unless that is specified in the power of attorney, the title company won't underwrite good title on it. And so I know Bob and I have talked about this in the past, and he sees that, and I do too. So there's language that he and I both put into our powers of attorney that makes sure that that spouse who is navigating all of the mess of Medicaid has all the power they need to do the best they can to pivot finances when and if the occasion arises that they need to do so. If I were there in person, I would be going, does that make sense? And I can't see a nod of heads. I can see maybe 6 heads in the video that I have. So what I'm saying is, if you have a power of attorney and you haven't pulled it out and looked at it in a number of years, please do so. And if you have that power of attorney and you think it's okay, maybe have your lawyer just put their eyeballs on it to go, are we good for Medicaid planning and gifting? In that general form, you'll see in those powers on the first page and second page where you just initial once for all the above. It says Medicaid, but that won't cut it. Not for title companies and not for banks anymore. And so there has to be additional language in the document that allows for that. So if you have that and you put that in there, you're really achieving the goal that we want with estate planning, which is allowing the person who's going to have to care for us with that document to do as much as they can to do what's in our best interest, okay? So definitely look at that financial power of attorney, and when in doubt, ask. And I will just give you my basic heads up about Google. Google is a fantastic thing, and it allows us access to a great many things. But because Medicaid laws differ from person to person, couple to couple, asset to asset, and state to state, don't take Google as an answer on whether or not your family will qualify for Medicaid, or whether you can or you cannot make a specific gift, okay? It will even give you differing advice on ladybird deeds, because some states treat ladybird deeds differently than Texas. And so when we are in Texas, we are a community property state, and we are very proud of it. I like to tell my clients, when we are born as young ladies, they swaddle us and they go, honey, it is a community property state, but we don't have alimony. And when young men are swaddled, they're told, oh, it's a community property state, so make sure your inherited property stays only in your name. So when we are looking at a point in time when a married couple comes to this point of needing to go into long-term care and pull out these documents in a situation where we need them, we just want to make sure they give that agent all of the power necessary to do what we can, okay? Texas is actually quite generous when it comes to funding long-term care, more so than you might think. So definitely an updated power of attorney for that is important. Secondly, when we're talking about that power of attorney, it is not required by law that the power of attorney be recorded with the financial power of attorney be recorded with the county clerk's office. I highly recommend that you record the power of attorney with the county clerk's office. And this is why. When that law changed in 2019, it gave certain liability or imposed certain liability on the bank that's going to be accepting it. So quite often that banker is going to be looking at that power of attorney with a certain amount of caution, which they should, right? And so when they look at it, sometimes what they will do is they will go back and they will say, I'll be right back, and they'll go check on that power of attorney on the online record system with Tom Green County. It's called Odyssey. If you haven't been onto it, it's really cool. But you can check online records, and when they see it recorded, they can also see that it hasn't been revoked and another person appointed. And that gives them some calm. And we definitely don't want the bank saying, we'll accept it, but it needs to be recorded. And then here you are, maybe it's your adult son or daughter trying to come in and help in an emergency in which they're having to step in as your power of attorney. They go to the bank, they present the document, and the bank goes, but I need to see it recorded. Now, is it legal to do that they require it? No, but at that point, what are you gonna do? Sue them? No, you're gonna go record it. Well, you have to put your hands on the original. Well, that can be kind of hard to do in that moment, especially if mom or dad can't remember where they put it or they accidentally lost it. And so it's really a good idea, if you have the original, to go ahead and record it in the county clerk's office. One, it's not very expensive to do so. And it gives peace of mind, okay? So we don't want, that's what this is really all about, is peace of mind. We want to ensure that when we use these documents, we can use these documents. And so not having to go on a scavenger hunt for the original to get it recorded is a very good thing. All right. Is that good so far on that?
Great.
Okay. So on the medical power of attorney, and Bob covered everything necessary on that medical power of attorney, but I'm gonna just double down and reiterate something that happens in my office. I will have people come in and say, I have never had to use that power of attorney. I'm making all the decisions for my husband right now without a medical power of attorney. Why do I need one? Well, if y'all haven't noticed, and I know you have, medicine has changed a lot since COVID, okay? I remember going to Shannon or to community before COVID, and I knew my doctor. I had some good idea who the hospitalist was, and he lived here, and he had a community of friends who were doctors here. But if you've been in medicine anywhere lately, or you've been in a hospital anywhere lately, you're noticing that it's a visiting doctor. And if you're in Shannon for more than maybe 3 days, you may have 3 different doctors visiting you at any given time. And so that one-on-one relationship that we've enjoyed pre-COVID with a specific physician probably has been compromised to a certain extent, okay? So having a medical power of attorney is important. Likewise, I can tell you from personal experience, I can walk in for my mom or for a loved one and say, I'm their medical power of attorney, and that's wonderful, except if my mom or my loved one can still convey by blinking or motioning of the head or anything else so that they understand what they're being asked by that doctor, I'm not an agent yet. I liken it to when the president goes into Walter Reed and he goes under anesthesia. He's not the president at that point. The vice president comes off the shelf and steps into the presidency until the event is over and capacity is regained by the president, the actual president. And so a medical power of attorney acts like the vice president in that situation. It comes down off of the shelf, we hand it over and go, we need to be making medical decisions because this person can't do so right now. Then the hospital will listen to you. But once capacity is restored, your medical power of attorney and your authority goes back up on the shelf. That document is very important to go ahead and put on your medical record wherever you may go to the doctor, but especially because we're kind of in a monopoly situation here in San Angelo at Shannon. It used to be that we would have to take it to medical records up on the second floor of Shannon, I think. They had the Mr. Ed door and you would just stand there and give it to whomever was there. And now you can take it to your podiatrist and they'll upload it into my chart, and then my chart shares it with everyone. And so if you make a change to that document, make sure that you put it over with them as well, so you keep them updated.
Karen,
I'm sorry, go ahead.
may we ask a question really quick?
Sure.
Thank you, Ms. Karen. I want to just revert back to what you said about the durable power of attorney, recording it with the county clerk.
Yes.
Is that something you would recommend for like our wills and our medical power of attorneys also? Is that, maybe a good proactive thing to do?
You know, that's a tricky question, and I'm gonna answer no. And let me explain it a little bit. Because it used to be a lot of people recorded their wills, so they knew where it was, right? There was an official copy of it somewhere that's certified and it's there. The problem is it's a public record. And so I don't encourage people to do that, one. And let me tell you why. I would encourage you to instead, in medical power of attorney, it can be recorded if you want it to, but put it with Shannon. No one's going to really look at it. If you put it on record with Shannon, you're better off than recording it with the county clerk. With regard to that will though, it's human nature, and I heard the question by the pastor talking about how specific a gift should be and letting mom and dad kind of get thrown under the bus, so to speak, with regard to any vitriol that might be there for who got the ring and, you know, who didn't get the set of Revere wear. But that does happen. But with a will, I don't know, it sometimes gets families in trouble before the death because they're not happy about what's in the will. And I think it's better to keep those things private, but making sure that everyone knows where they can find these documents in the event that they need to do so. So I'll tell you a kind of funny story, but it's a true one. And this will go back to about 10 years, so not even that, maybe not that long. I'm sitting in my conference room and I'm telling you all how to do it, right? And my client's in there, and I have my cell phone in there because we're looking something up, but I generally don't have it in there. But the phone rings and it's my mom. And so I click it off because I'm like, oh my gosh, I'm so sorry to my client. I click it off and I know that I will call her back as soon as my client is gone. So client leaves, I call mom, and she said, and she lives in Mertzon, she's on her way into town, and she is having a heart attack. And so, oh my gosh, I can't believe I clicked off the phone, right? And I'm like, oh my God, mom, are you almost there? And neighbors bringing her in. It's just happening, right? It's all happening. And so here, I do these documents for a living. And my mother has all of her copies in Mertzon of these documents and does not have them on file. And so here I am rushing up, and I'm having my staff feverishly write a new medical power of attorney for my mom. This was before we had my chart, right? Before we could put things on my chart. But I got there, and I had they were following in hot pursuit behind me. My staff are fantastic. So I can get her signature, and I'm too late. She's already in having surgery. And so when you put these documents somewhere, I knew where they were, and we'd had some back and forth. I don't really need to get a copy of your documents, Mom. But in the pinch, luckily God was with her, and she survived everything just fine. But getting a copy of those documents, you may not even, it's always later than you think on getting around to actually organizing these beautifully written things into a place where they can be found, okay? So at that point, in that particular situation, imagine me trying to go home or look up in a file somewhere, a mom file somewhere, a copy, or trying to get it from the clerk's office. That would have all been too slow. Definitely the way we did it was too slow. I can't drive out 25 miles to Mertzon to get it. But imagine if I just walked in and they pull up my chart and they see me. That's all they had to do. So my recommendation is my chart for that. Put it on file with Shannon. If you're at a specialist in Dallas or anywhere else, put them there too, okay? In our office, we give you the original back and we make you 5 copies. And we tell you, do not take the original apart. If you run out of copies, call us. We will give you more copies because we keep them, okay? We scan it into our server. And we also keep paper copies, so we can always get you more copies if you're out. You can make copies of the copies as well. Just don't mess with the original. You run them through a copy machine and it decides to make a paper airplane out of it or an accordion, and there you've lost your document. So that's my recommendation.
Karen,
does that help?
Karen, excuse me for interrupting here, but on this question, I made a note here and wrote it down. It's amazing to me in an entrepreneurial country like America that there is not an industry of people who create storage that's perpetual and secure for these documents that's private. I left my stuff with my attorney, and he died. And
Oh,
when I went back to
absolutely.
get it, it had already been handed off to somebody else who had handed off to somebody else, and I didn't know about his death because I had used his services. So that was no good. So what I'm asking is there a perpetual secure storage company or nonprofit organization that will take these documents and keep them privately stored where everybody knows, like my family's scattered all over the United States. My executor's in Colorado. If something happened to me overnight, I would like her to know, go there or call there, and they have all my documents secured, ready to give to you for what you need to do. Is there any such service like that? And if there isn't, why not?
All right, so that's an excellent question, because that gets to the heart of, what happens? We pull these out, where are they? Where can we, and do people know where they are? I'm sure you can find that. I'm not aware of a service that provides that. That doesn't mean it's not out there, okay? The difficulty is that technology changes so fast. So imagine if I had this 10 years ago, and it gets flipped or updated or sold to a new entity. Or, I know there's data that I had to pay to convert, and it becomes expensive, and it's a subscription, and things that I used to have downloaded are no longer downloaded. My point is this: when we put that document out there, it is public knowledge. You have to assume, even if they say it's encrypted and private, that it may not be. And so, still utilitarian, absolutely. You could possibly set that up and put it in or onto a Google Drive that you give somebody access to without actually having to pay. But a secure encrypted environment where you're placing that gets into, I don't know of a service that provides that. There may be one. Even if you find one, I would question whether or how accessible it is. Or will it be accessible X number of years in the future? And so it's an excellent question, but I don't know of one.
We have another question here, Karen, hold on.
Yes.
Karen, first of all, I'm sorry John is sick. Give him our best, please.
Do you know how terrible it is that two lawyers are fighting up? He's sick and he's on the other end of the house and he's got a suit on from here up. Trying to do hearings. And I told him, I said, you're too loud.
God bless y'all. So if you're on vacation, because many of us are at the age where we can travel when we want to, or mostly, what would you suggest that we take with us?
Oh, great question. So, I have clients who actually take copies of these documents, and so I would at least reduce them. This is what I did. I actually scan. I have an app on my phone called Scannable, and it allows me to take a picture of something like these documents, and it uploads them, right? Or I can email them to myself because I can scan from my office to my email, pull my email up mobily, and there are my documents in a PDF, right? But I have a scanner. If you don't have a scanner, you can get an app scanner that will pull them up and save them in your camera, and you can share them with whomever you wish that way, just like you would share a photo with someone. I don't want you to do that with a will, that can wait, but just to make sure that you have these documents, that's what I did. To make it easy. Now, I have people who do it differently, right? I have people who don't have cell phones or that technology is more than they want to mess with. I actually had a gentleman who went to Kinko's and he reduced his 8.5 by 11 to something about this big. He had them laminated and he had them put on a carabiner hook, like a pass, right, to a concert. They're all on a carabiner hook, and he has them he carries them like keys, hooked up to his stuff, and he keeps a copy in his glove compartment. And so, I don't know how a place would accept that, how that would work out if you actually had to pull out that thing and use it. But definitely keeping a copy of them accessible is easy. The phone is easy because if you have an iPhone especially, I can hit that little box that has an arrow and punch it and print it off right there on their printer or share it to where they need me to share it. So that's worked out very well. I have actually used that. As you know, my William is just turned 18, and so we were just on a trip that was college trip, which is I think what gifted Daddy this for Father's Day. But I had to have William's documents because gosh, he's 18 now. I don't get to speak for him. Well, the first thing I did when he turned 18 was say, "Happy birthday, William. Here's your medical power of attorney, your financial power of attorney." And we did not do a directive to physicians. But I did all of those in a HIPAA release. HIPAA, we'll talk about that in a second. But I did all of those things and I reduced them. I hit with scannable. It turned that picture into a pretty clean looking scanned copy. And when I needed that for all the medical releases for college, I just hit send. I emailed them right from my phone. So it's super simple. But you know, we think about end of life with these documents, but the truth is everyone over the age of 18 needs these documents. Does that help, Linda?
Yes, I think so.
Yes.
Okay, I have one thing to add about HIPAA on that. So, does everyone know what HIPAA is? Yes, okay, so, you know, your privacy, your Healthcare Portability Privacy Act. So, that's the little document that is just kind of a pain in the butt for attorneys because we're so used to printing the will and the trifecta, right? We do the medical power of attorney, the financial power of attorney, and the directive to physician, their living will. And so HIPAA, we have to remember, because some of us are old enough to remember, we have to throw HIPAA in there. Well, with what I do, it's part of the quad, I call it, because HIPAA really didn't seem very important until COVID hit. And I get very serious about COVID, that's why I'm not with you today. I know all of the politics around COVID, and I don't mess with all of that. But I know that when those hospitals closed down, and you had people who could not see their loved one in hospital or enter the nursing home, they had to pick up the phone and say, "How's my dad today?" And if you didn't have a HIPAA release, you didn't get to find out. Now, that's horrible, especially if they're passing away. All right? So if you don't have a HIPAA, get a HIPAA. It's not a complicated document. But I now consider it as important as the others. Just because a pandemic will do that. It will find the little piece, the little cog in the machinery that you don't have and shut it down. So if you don't have a HIPAA release, get a HIPAA release, okay? And keep it and share it just like you share that medical power of attorney with Shannon. If your loved one's in a nursing home, give that medical power of attorney and that HIPAA release to the nursing home, okay? Because there's probably a hospitalist with a nurse practitioner who is visiting your loved one in the nursing home. They're not putting them on the bus all the time and taking them into Shannon for care. Often they're receiving it in the nursing home, okay?
Okay.
All right.
Any other questions?
Ms. Karen, a follow-up question on where to store the will. So
Yes.
if we shouldn't record it with the county clerk, and I've heard that I shouldn't put it in a safe deposit box, where should I put my original?
Mine's in the safe deposit box because I've got 4 years to probate a will, and I figure my husband will have time after he's picked out the clothes he's going to bury me in, and that debacle of me being mad at him from heaven, going, "You picked that star." He has 4 years to go down there and pick out that will. I have my bank account set up so it passes automatically at death to him, so that he has access to cash. So our checking account isn't shut down because we didn't set it up to automatically pass to one another. Bob talked about that earlier. But he's gonna have access to cash. When Monday morning rolls around and he feels like wandering into the bank with the key and opening it up, that's great. Now the problem is if we're killed mutually together, who has that key? Well, I gave that key to my brother, I gave a copy of it to my brother-in-law too. Now assuming, bigger things are happening and nobody can find the key, then we're gonna have to have it drilled. And there is a provision in the estates code that allows the court to have the thing drilled so that we can get the will out, okay? When, you know, there are alternatives. You don't have to put it there. You can put it in a safe place and just let everyone know, here's the plan. I have a recent estate in which that was done, a full instruction list, and I so highly recommend this. A full instruction list of, here's where everything is, here is where I bank, here are, you know, how many accounts I have and the account numbers. You know, something, think about all you know that your kids don't know and won't be able to find. They don't have to know how much is in there. They don't have to have the authority to talk to anybody yet. But think about all you know that your kids are gonna try to figure out. It's a breadcrumb trail, right? That you want to leave for them. And they don't have to have all of that right now. They just have to know where to find the list. And the list will lead them to everything else. And so, I know it's a pain, but it's necessary. And if you're one of those people who puts things in a safe place in your house, and then you move, you know, the money in the mattress, or you die and nobody knows the money's in the mattress, or you're like me, I hide it from myself, and then I have to go on a journey of discovery to find out where I hid it from myself. You know, putting something in a safe deposit box isn't a terrible thing, or a safe at home where somebody knows where to find the key. And I want to loop back to the question about attorneys dying. They die, we retire, we do all kinds of things. And so that's why I do not keep original wills at my office. I do keep copies of everything, but it's important to know that that's a good question to ask of your attorney. I could work for another 50 years, I could keel over tomorrow. But at the end of the day, we're just people, right? And so when we're wanting to find that plan needs to exist outside of your attorney's office, especially not just on wills. I mean, you have all kinds of things like that you need to be able to put your hands on, like separate property or community property agreements. You need to be able to put your hands on a prenup if you have one of those. Those are always fun, where somebody passes away and they come in and they go, I know there was a prenup, but we can't find it. You know, there's all of that, and you get into the back and forth with families. But, you know, those kinds of agreements are legally contracted documents, and if you can't put your hands on them, then they just don't exist, okay? So I hope that helps.
Do we have any other questions, Karen? We got another one here, Karen.
Yes.
This is more of a summary question. For children who are 18 or over, the financial POA, the medical POA, HIPPA, I thought you said it was a quad. What's the fourth thing?
The quad is one I didn't do for my own son, and that's because, Mom, it's tough to do a directive to physicians that says not to hook him up to life support. I'm gonna let that be my choice, because Dad and I are still here in that situation, one. And two, well, I'll tell you why in just a second. Stay on point. It was just too uncomfortable for me in that situation, and I'm not saying it's not uncomfortable for everyone. I have one on my own life. I know what I want done and I don't want done, okay? I've seen so much in my career and been there with multiple people who have passed on, because sometimes the lawyer is the person they call, right? And they're alone and they're passing, and by golly, you go and you're there. And I don't think it's cool for somebody to pass by themselves. So I've done that, and so in that situation, I knew I wanted my document to say. And if I have a terminal or an irreversible condition in which I'm not expected to live more than 6 months, no matter what you do for me, or that I have no quality of life, and without this extraordinary thing to keep me alive, you know, I'm gonna pass, let me go. That's how I felt about it. That doesn't mean that's the right decision for you, right? But in that situation, I didn't do one for him, because I didn't think, it's not my decision to make, it's his. And that's a pretty heavy thing to put on a kid for his 18th birthday present, so I didn't do it. But as his medical power of attorney, if he doesn't sign that, I do have the ability, in the absence of the directive, to make that decision anyway. And I would hope that I would be there to be able to do that.
Thank you.
But, so technically that's it. But let me add, I could add a quad to that if you'd like, and it's one that really came to mind, and the attorney doesn't draft this, but if you are going to be contacting colleges or something like that on behalf of your new young adult, they don't talk to you unless your child or grandchild signs a FERPA release, FERPA, that gives the school the ability to share information with you. So there I am, the person who's gonna be writing the checks for tuition and all of that, and I'm trying to make sure all the ducks are in a row, and they're just kindly nodding at me, and William had to sit there and be my go-between, because they can only technically, legally talk to him. So, it's funny, I at one point, I know this is the rule, and I'm still sitting there going, do you know how many zeros you want before that comma? You better look over here and talk to me. And they were kind, but legally, a FERPA release has to be signed. So with that with each institution, that is not a document that you would add to estate planning documents, but it's still very important. Imagine something happens to him and he's at Trinity or Cornell or wherever he's gonna go, right? And I call and I go, oh my gosh, this is going on with my son. They can't even confirm he's a student there, okay? So get a FERPA in there. And there are also medical releases you sign with those institutions. But understand, my medical power of attorney for my family here, that's a Texas document. It may not be honored in the same way out of state. So if you move out of state or intend to move out of state and stay there or visit out of state long enough, you may want to go ahead and get a document in the state in which you're going to be residing that complies with the rules of their particular state, okay? So I know that most of these documents look a lot alike between states, especially when it comes to medical, and HIPPA is a federal document, so it applies to all 50 states. But that financial power of attorney is very much a creature of the Texas legislature. So do not count on it to work for you in the same way it may work in Texas if, say, you move to New Mexico or Oklahoma. And God help you if you move to Louisiana. Because Louisiana runs on French law. It is Napoleonic Code stuff. And so Texas runs on, our background is English common law, going all the way back to England, jolly old England, but not in Louisiana. So don't count on something working there that works here, even if it worked in New Mexico or if it worked in California. Louisiana is really its own backyard. So anyway, I hope that helped.
Yes, Karen, is there any other new subject that you were gonna cover before we start
Yes.
wrapping up? Okay.
I am so sorry, I know I'm speaking too long, and I would love to be there in person today, and I probably would have a more metered approach. But I want to tell you real quickly about what happens if you don't get these documents done, okay? Bob talked to you about wills and who inherits if you don't have a will. If you don't have a will, the state of Texas has written one for you. You may not like it, but there is a will out there for you. But if you'd like it to be personalized, go in and sit with a lawyer and do it. Just do it. You can print one off the internet, but if you don't execute it right or it doesn't meet the formalities of Texas law, I can't take it through probate, okay? Judge won't approve it, and we have to go back to the backup will that the state has written for you. And Bob talked about that. But if you don't have powers of attorney, here's what happens. People come into my office and they go, okay, husband's going into nursing home. I need to go through and apply for Medicaid, and they sent me to you, Mrs. Best. And I go, that's great. Let's sit down and look at all of your assets. Do you have a power of attorney? No, I don't have one. Or it's one that I can't use because it's old or it wasn't executed correctly, okay? Or it doesn't say in there the powers that we need. All the things that make it not work for me. Where I can't go to the bank and use it, or I can't execute a deed that Bob Post is going to give a thumbs up at the title company, right? Even that Ladybird deed. Then I have to go to court. And I love our court system here. We are so lucky in Tom Green County to have very accessible judges and very accessible courts. Our county court and our 2 county courts at law. And so while they are incredibly helpful, they have to follow the law. So if we go into Judge Lane Carter, for example, and we say, Judge Carter, we need help. This power of attorney isn't working and we need to do these things. Then he's gonna have to have us go down the route of applying for a guardianship with the court. That means that since we didn't have documents that worked, or we didn't have them at all for agency powers, the trifecta or the quad, financial power of attorney, medical power of attorney, especially, we have to get either apply to the court to be granted a guardian of the person, giving us all of the powers of, say, the medical power of attorney, or guardian of the estate, giving us all the financial authority. The difference is this: we don't just walk in and the judge go, okay, I'll give that to you. We have to literally sue your loved one. I have to sue the husband who's in the nursing home. I have to file a document that says, you have dementia, and we have a sheriff's deputy take the lawsuit to the nursing home and serve it. Do you know how scary that is for that individual to receive that? And so then that person is appointed an attorney. So I'm the wife's attorney, and we go into court and say, we really need it because we have to go gather all the financial evidence, because this is a trial very much like any other. The attorney representing the husband has to work with us. They may fight us. The husband can go, I don't want to be here. I want to go home. I don't want a guardianship. She's trying to kill me. You know, all the stuff that comes along with crisis, right? So we convene with a trial. You have two attorneys at the trough. Do you know how expensive we are? And so there we are. We try to be reasonable. It's not like we're sitting there trying to gouge people in this court. But we have to get a guardianship. So we have a trial. We prove to the judge that there's a need. You have to get up there. If your husband decides he wants to come to court and have his day, wife has to sit up there on that stand and testify against husband to his face, to lay down why we need this guardianship. Or adult child has to sue and tell mom why we have to take her rights away. So when I'm executing a power of attorney, I'm choosing my agent. But I haven't taken away my ability to do things as well. In guardianship, you are sued. And the child or the loved one who's stepping in, or the friend, for goodness sake, who is the only person left, is trying to help you not be taken advantage of by the scammers, or whatever the backstory might be, they have to sue you. And they have to testify against you in court. Both lawyers get paid for a trial and all the preparation that goes with it. And then the court, if they grant the guardianship, takes your rights away. You no longer have a legal right to drive, to manage your finances. You know, it's not a one-size-fits-all, but all the things you can't do anymore are gonna be in a court order. And the only person who can give you those rights back is the judge. And that is another hearing as well. So you can see where all of the civil liberties that we so enjoy are suddenly compromised in a way that we never thought about. And that's primarily because we didn't do a power of attorney. And so it's an easy fix. There are times with even with powers of attorney, we have to go into guardianship. It's true, but it's not often, okay? So if you were going to do something that really helped you get your house in order, you're gonna do the easiest documents in the law to do, which are the financial powers of attorney. Because if a guardianship is granted, your guardian of the estate and guardian of the person has to account to the court every year for every penny that they've spent. They can't, on your behalf of your money, they cannot sell a house or do anything else without going to court. And they cannot go to court without the lawyer. So I hope that scared the bejesus out of you to go as an attorney. And I love guardianship, and I love, it does beautiful things, and we have stepped in and done amazing things in guardianship court that you would think couldn't be done. And I will tell you that Judge Nolan has met me years ago on Christmas Eve at a gas station to sign a court order. Judge Brown, Judge Floyd, honest to goodness, Judge Carter is simply amazing. We have great judges who care very much, and we do try to make that issue as easy as possible as you go through it, but it's still a heck of a lot harder than having these documents done. Does that help?
Yes, that is awesome. And you know, just from a personal standpoint, I had a parent parent who did not want to sign a medical power of attorney, any financial power of attorney, because they thought they were giving up their rights. But what you're telling me is they're keeping their rights to do that.
If you would get on a billboard with me on Sherwood Way, that is the front and the back of the proverbial t-shirt. That is exactly right, because the alternative they're leaving you is taking their civil liberties away with a court. They're literally going to be sued in that situation. I also have individuals who have been taken advantage of, and unfortunately, fortunately, we're a senior community. I love that about San Angelo. We draw people from all over the counties, all surrounding, about 11 counties come here now for care. But unfortunately, that also attracts the bad guys, right? And so think about that. Mom is being taken advantage of by somebody, and you can't step in to stop her from, taking $1,000 out and putting it in an envelope to her new best friend in Guatemala on a burner phone, right? That happens, and y'all know stories about this. I mean, pick a flavor of crook, and they're out there. But that financial power of attorney can immediately step in, especially if you've elected that they can work alongside of you without having to get a letter from Shannon, which is very hard to get right now. So unless you're at Shannon, and then they'll help you with it. But if you're on the outside banging and knocking on the door to ask Shannon for an incapacity letter, good luck getting that very quickly. So in the meantime, the bad guy has instant access to the ATM, right? In guardianship court, we can step in an emergency situation and probably get a turnaround in an emergency situation, God willing, and the creek don't rise, of 2 to 3 days, especially with a proactive judge and assigned attorneys working on it, and get those letters of guardianship to step in. But the crook has a 2 or 3 day lead time on us. And so having a financial power of attorney that allows your agent to work alongside of you is, not instead of you, but alongside of you, really does allow them to just go, hey, I'm going to the bank, I'm going to First Financial, I'm going to Sonora Bank right now, and I'm shutting the pipeline down, right? Before there's no money left.
Thank you, Karen. I'm thinking she's been pretty clear on that. Unless somebody has another question, I think we're gonna thank her so much.
Thank you for letting me do this virtually. Next time, I promise we'll try to be well for in person.
We appreciate you coming, and give your husband a hello hug from across the room from us, and thank you for letting you come and be with us today.
Yeah, I'm giving him an across the room hug too.
All right, thank you so much, Karen.
Thank you.
Bye. It's going to be awesome. We have to talk us, and thank y'all both so much. And I want to tell you that lunch is ready. So it's going to be right outside the double doors. There is a donation box. I think most of y'all have heard of that. That will be there for you. So you can go on either side of the table. So you can start here and then go down this way. And you can come back in here and eat. And there's also dessert. And I believe probably some tea and water. So thank y'all so much for being here. We hope that you found this helpful.